Thank you so much, everyone, for staying with us. Let's go back to our major story tonight. It's about the defection stories. And interestingly, in two states, Ebonyi and Cross River State, the issue of defection has gone to court and is causing a lot of legal battle. So another one has happened today, and that's in Cross River State, involving 20 former PDP lawmakers who defected to the APC. Well, there are issues that have been brought up in that matter. Some of them claiming that the APC says some of them are not even the members. Some of them are saying, well, there was a crisis in their party. In fact, the lawyer is also saying the court does not have jurisdiction because it was taken out of Calabar where the event happened. What does the law say about all of this? Tonight, I have a senior advocate of Nigeria who interestingly has had on several political stories, legal issues in court. Senior advocate Jibrin Okutapa joins us now tonight. Thank you so much for joining us.
Sure, it can only take your...
Thank you so much for coming.
Thank you.
I know I pulled it out in just a few minutes.
Yeah.
Thank you so much for coming.
Thank you.
And we have a legal scholar also, Evans Ofeli, who joins us from our Lagos studio. Thank you so much, Mr. Ofeli, for joining us.
Thank you.
Let me get your legal opinion on this. Now, 20 of the lawmakers from Cross River were sacked. This is similar to what we saw in Ebonyi State. Some lawmakers were involved, but the governor and the deputy governor were also involved. What does the law say about defection? Does the law envisage that state lawmakers are going to defect? For those who argue that it was only the House of Reps that was envisaged in the issue of defection as captured in the Constitution. Give us an understanding of what the law says.
Well, Shenwa, I need to be very careful here because most of these matters are in court. Unfortunately, Nigerians are interested as to why at this material time, if we are to go on the parameter of morality, whether those who were themselves beneficiaries of these constitutional iniquities can be allowed to approach the courts to seek equitable remedy of a declaration.
Or protection.
Or protection. We all, like I said somewhere yesterday, Nigerians are not stupid. We are very inquisitive people. Yes, it is true in our constitution, two categories of political office holders, the legislature and the executive, had separate provisions in our constitution as to what they needed to do and where they needed to stay in terms of parties that sponsor them to political offices. In terms of legislature at national level, for instance, Section 68, subsection 1G of the Constitution allows a legislator to defect, provided, of course, that there is a division in the political party upon which he rode to the National Assembly, and so on and so forth. For legislature, there are conditions for which you can defect. And if those conditions are not there in the Constitution, then you are likely to lose your seat. The Supreme Court has said so in Abegunde, the matter that happened from Ondo State. And then there are definitions of what constitutes divisions in political party. It's not a self-induced division. It's not a division of a crisis you fomented yourself and wanting to take advantage and benefit of it. It must be a division that is sort of a magnitude that the political party itself cannot function at national level. Those are the conditions that the Constitution stipulates. So, as for Section 68, subsection 1G or 2G of the Constitution. Now, as for the executive, I was having a discussion with a learned scholar who took me on memory lane to the 1999 Constitution and said that under that 1999 Constitution, 1979 Constitution, I have not had the privilege of reading it, that also the executives were not allowed to defect. And that if you defect, you risk losing your seat. But under the 1999 Constitution, You will recall that the former Vice President of the Federal Republic of Nigeria have had occasion to defect from the platform of PDP upon which he and Chief Olusegun Obasanjo were elected to join the political party then known as ACN, Action Congress of Nigeria. Now, Chief Olusegun Obasanjo at that material time had said by virtue of that action of His Excellency Alhaji Atiku Abubakar, he is deemed to have resigned from the office because it was not envisaged morally that he will leave the party upon which he was elected to another political party and engage in political contest against his own political party. The matter went to the Supreme Court, and the Supreme Court, upon interpretation, says that, in summary, without quoting their lordships, that a member of the executive that defects from a political party to another party, from the party that upon which he was elected, does not lose his seat. So the matter is in court. In case of Ebonyi, for instance, I listened to my learned brother Silk that the appeal had been entered. The Court of Appeal is now seized of the matter. We want to wait for what the Court of Appeal will say and the firework that will go on there. But let me say this, that I welcome some of these decisions, if only it will instill political debate, political sanity, and so on and so forth. If our judges now can give effect to our constitution. But something worries me, and that is, why is it that all of these matters are brought to Abuja?
That's a matter of jurisdiction now.
Why are they brought to Abuja? There are decisions of our superior courts that, notwithstanding that the Federal High Court has one territorial jurisdiction, that territorial jurisdiction is Nigeria, there are divisions of the Federal High Court. For instance, in Ebonyi, for instance, in Calabar, for instance, in Enugu, for instance, even in Kano. There is also one in Makurdi, for instance. Why are litigants rushing to Federal High Court in Abuja? We are put at disadvantage, those of us practicing law, who are not handling this matter, because this is a matter of national and sensitive importance. And in most cases, their lordships, with their overloaded docket, have to abandon other matters for these matters.
And speedily attend to it.
And speedily attend to it. If you look at the way and manner the matter that was filed in Umuahia traveled within 11 days, service, filing,
some will even say 10 days.
Concluded. If that is the speed at which justice travels in Nigeria, majority of us would have not been worried. So all I'm struggling to say is that Nigerian judiciary seems to have been overwhelmed and overworked with political cases at the detriment of other equally important cases pending in court. So my take, therefore, is that we should be worried that matters which ought to be filed, for instance, in Calabar, have been filed in Abuja, because the defection did not take place in Abuja. The House of Assembly of Cross River State does not sit in Abuja.
So it should have been heard in Calabar.
It should have been, because that's
at the appellate court. How critical does the court look at the issue of jurisdiction?
Well, jurisdiction is the
Can it affect the meat of the matter?
Jurisdiction has been equated to the blood in human being. Without jurisdiction, whatever decision that the court render, however beautiful it is what we call ex nihilo nihil fit. From nothing, nothing comes. So if there is no jurisdiction, therefore, it's an exercise in futility. So it's a crucial constitutional and jurisdictional matter that needs to be looked at. And we need to let our political office holder approach courts that federal government has established within their territorial jurisdiction. For instance, the defection of members of Cross River State House of Assembly took place in the precincts of Cross River's House of Assembly, a territory not coterminous and the same with the Federal Capital Territory. So the course of action happened in Cross River states.
All right.
And then when we talk about course of action jurisdiction, where did the course of action take place? It is in Calabar. Where are the lawmakers reside? It is in Calabar. Right. Is there any federal high court in Calabar? My answer is yes.
All right, just a moment. Let me go to our Lagos studio. Mr. Ofeli, there are a series of precedents that are very much alike into this matter. You look at Abegunde versus Ondo State House of Assembly. In the case of AGF versus Atiku Abubakar. In the case of INEC versus Amechi. In the case of APC versus Marafa, you can mention on and on of some of these cases. But in this particular case of the Cross River State House of Assembly members, is there anything different? Is there anything novel that has emerged from the judgment of today that you can tell us?
Well, the judgment of today is just in line with what the Constitution have provided. There is nothing novel about it, because the Constitution has clearly stated that, you know, for parliaments or legislatures, you cannot just defect. You must show grounds upon which you are taking such decision. And where the court is not satisfied with the grounds, just like in today's case, the court said that the documents presented by the defendants, you know, were defective, okay? That they have dined and wined with the PDP only to ditch the PDP at some point. So I think that political harlotry should come with severe consequence. And I think that Nigerians should welcome judgments like this, because politicians must be disciplined, no matter how you look at it. Okay, it is this same indiscipline that they have taken across board. It is the major reason they are unable to provide good governance for the people, that level of indiscipline. So when you look at it critically, you find out that our judicial system is taking our political system to growth. Okay, it's instilling discipline gradually. But the only area where I have problem, like the issue of Ebonyi State, are the consequential orders that the courts are giving. Okay, because when the court make consequential orders that the PDP should feed in a candidate, and then you look at section 141 of the Electoral Act, which says that if you do not participate in an election in all the stages, you cannot be a governor, then you find a conflict there, okay? Because what you have now is a conflict of law. Those consequential orders cannot stand the test of time. Even in the case of today, where the 20 lawmakers are being asked to vacate their seat, what is going to happen? Are we going to now, is the party, the PDP now going to feed in candidates that did not contest elections? Or how exactly are you going to come about that? So those consequential orders, we must look at it. I think that the Constitution must be tinkered in such a way that the orders of the courts, as they are being made, will be in sync with the provision of the law. Because after making the pronouncement that you defected from this political party to this political parties, your vote, you cannot transfer it. The people or the electors who voted you on the basis of the political party that brought you to power, and now you are no longer there, okay? And now the court is now making consequential orders to say that, okay, the party should now feed in candidates in those positions. Are you going to do that without election, both at the parliament level or at the governorship level? So how would this candidate emerge? Those are other jurisprudential questions that we must put forth. And then we are able to marry it together, because what we have.
Okay, so I wanted to put in this question. One of the major bases at which you find lawmakers defecting, and I think it's decided in law that there must be a crisis upon which the decision of your movement must be premised on. So this, and the law also specify where the crisis must be It must be at the national level. But, I mean, where there is a crisis in this sense will be an issue for argument, in fact, when this case goes for an appeal. But the big question here is that what is the fate of these lawmakers as it stands? Because there are also deniers that APC, part of the case, or the argument was that they were not members of their party. What happens? How do you define crisis? What makes up a crisis? How does the court see a crisis?
I think in the eyes of the law, a crisis will be what the law says it is, okay, and not coming up with letters of dismissal. Okay, the Constitution did not talk about letters of dismissal as the 20 members are banding around the document to state that the party had expelled them even before the defection and all that. So crisis in the context of this would be, jurisprudentially speaking, what the court mean to be crisis. In this case, Justice Taiwo, okay, came to the conclusion that the document presented by these lawmakers are defective. They have no probative value, okay, to warrant them to have defected from their political party in PDP to APC. Okay, so that will remain a context on appeal. Okay, it is not the appeal court that will determine whether or not those expulsion letters are being tendered as evidence will stand the test of time, because what we have now is that the court have utterly rejected those documents. There are no evidence. They are evidence without probative value, so they cannot stand the test of time. Most of the time, these political parties go and orchestrate the so-called division, orchestrate the rancor, and then defect, then turn around to say that it is because of the same rancor that they cooked up themselves, or the same division that they orchestrated surreptitiously. And then they want to use that to convince the court. I mean, the court is not a church. The court is not, the court will look at the issues beyond the surface, and the court will brood into the intent and intention of the evidence that are before it, before the court can admit and believe such evidence. Even when the court admits such evidence, the probative value and weight it will place on those documents will be based on its veracity and the weight of law that is put forth.
I don't know whether, Senior Advocate, you might be able to educate us. We are due for a break. I want us to come back and quickly wrap up. You educate us whether or not at the appellate court you will be able to argue some of this evidence, whether they be tenable at the appellate court, or, I mean, what is the fate of, they have the right of appeal, isn't it? They can't lose their seat if they go on appeal immediately.
They have the right of appeal. I agree with my learned friend that if the tempo of judicial sanity being instilled in our politicians are maintained in the right place, I should be the one celebrating it. But I'm worried that, yes, their lordships have done what they needed to have done, but the question of jurisdiction that we have raised are fundamental, and I'm happy that my learned friend, Mr. Ofeli Evans, agree about the question of jurisdiction. I agree with him about this. But when you talk about those branding documents, I heard my learned brother, Chief Michael Zokome, talking about being expelled. Now, there are a lot of difficulties that some people I'm encountering as to the question of this defection and becoming a member of another political party. Now, how do you prove membership of another political party? Is it by newspaper cutting? Because if APC, for instance...
What about the verbal announcement on the floor?
Because membership of a political party is not an announcement on radio. You must be a member of a political party. Did they tender the register of voters of APC containing their names? They have been registered there. We are talking, and I'm happy that my learned friend says court is not a church. We are talking about court of law. How do you prove, for instance, that Mr. Kutepa is a lawyer? Is it by parading myself around on the street of Abuja and calling myself lawyer that makes me a lawyer? Or you want to know if I was a lawyer, if my name is on the roll of the Supreme Court.
So, Senior Advocate, just
yeah.
give me a moment, because I want us to come back quickly and wrap up on this one and put a note of finality in our conversation tonight on this matter before we move on. Stay with me, everyone, because when we come back, the learned legal minds in the studio with us will be giving us their final thought on this matter. Plus, we look at what is happening in the APC. It's just how many days now before the National Convention, but who becomes the next APC chairman? One of the contenders will be joining me in the studio right here. Stay with me, everyone. We'll be right back. Thank you so much, everyone. Let's now conclude the thoughts on the issue of defection. The latest being the one from Cross River State that was decided in the Federal High Court in Abuja today. Will these 20 lawmakers from Cross River lose their seat in the House of Assembly there? Some of the legal minds that are talking to us tonight: Senior Advocate of Nigeria, Jibrin Okutapa, here in our Abuja studio, and Evans Ofeli, a practicing lawyer and a legal scholar from our Lagos studio. Thank you so much, gentlemen, for your time. So you said, Senior Advocate, that they have the chance of appeal, right?
No, they have a right of appeal.
Yeah.
Everyone that is dissatisfied with the judgment of the court has a right of appeal. But if you appeal does not operate as a stay of execution. So
I thought an appeal is an automatic. I mean, when you file for an appeal.
No, the appeal does not operate as a stay of execution. So if you want a stay of execution, their lawyer knows what to do, and they will file the relevant processes.
I'm wondering why the Ebonyi State Governor and the Deputy withdrew their stay of execution.
Because the Court of Appeal and the Federal High Court do not exercise a coterminous jurisdiction. Once an appeal has been entered in the appellate court, the lower court ceases to have jurisdiction, because the Court of Appeal has become the dominious litis, has become seized of the matter. It has the whole power over the matter now. So a stay or not stay can only be ordered by the Court of Appeal. So the Federal High Court no longer has jurisdiction, because the appeal has been entered. There's a distinction between entering an appeal and filing an appeal.
Okay, so as soon as you enter an appeal and it's registered
with the appellate court, appeal number is given, record has been transmitted to the Court of Appeal, appeal has been entered. So every application, even the one pending at the trial court,
all injury, all action will be pending.
The Court of Appeal will be the one to become the master of the proceeding. So the lawmakers will know what to do. But my worry, and let me say this on a final note, is that while I salute the courage, the doggedness of the pronouncements of their lordships, which I welcome, and like my learned friend says, which will instill political sanity in an otherwise insane political environment in Nigeria, we must be very careful in order not to waste our resources in a wrong forum, because the forum of adjudication is fundamental. There are decisions of the Supreme Court that you can't take a matter that happened in Sokoto, for instance, and bring it to file in Abuja, because there is a Federal High Court in Sokoto. And why do we waste our resources to establish this court and bring the judex nearer to the people? If people can be brought from Sokoto, for instance, to Abuja to adjudicate over a matter that happened in Sokoto, because the place where the cause of action arose is crucial for the determination where the defendant resides. Now, the 20 lawmakers of Calabar, for instance, or Ebonyi, are not residing in Abuja, although they frequent Abuja for purposes of comfort. But does their frequency in Abuja translate them to be resident in Abuja for purposes of sue them before the Federal High Court in Abuja? Final point that worries me is these are controversial issues of that you talk about forgery or not forgery, and they all began by originating someone in affidavits. How do you determine authenticity or otherwise of allegation of a forged documents of expulsion under originating someone, which is supposed to deal with a question that does not involve a substantial dispute of fact? There is a dispute as to whether or not APC, for instance, from what I heard you say they are not my members. Then if he said, if you defect and become a member of another political party, membership is proved by membership card, by membership registration, the register of vote of a member of the political
party. Not an equity, not a
membership. Not newspaper court, because anybody who doesn't like Shehu Okibaloye, for instance, will now say Shehu has resigned from channels. How do you prove that Shehu has resigned? We need to call the channel people whether Shehu has a letter of resignation with them. And indeed, he has taken up appointment with the law firm of Mr. Okutepa. We need to find out if Okutepa had given Shehu Okibaloye a letter of employment, and then they say you are impersonating as a lawyer. So, which court did you appear?
So, how to prove that becomes...
So it is easier, and I'm happy my learned friend said that that the court is not a church. Yes, if it's a church, it's a question of morality. But what is the distinction between morality and legality? There are too far poles apart. So what I talk law, I am not... yes, it is morally wrong for a politician to jump ship. But how morally upright are they, even in governance?
Thank you so much, Senior Advocate. I sincerely must thank you for your thought tonight. It's very much appreciated. Thank you so much. Let me go to Lagos and get the final thought of Mr. Ofeli. On this note, what is the biggest lesson that Nigerians must take out of this?
Yeah, the biggest lesson Nigerians must take out of it is that it is now an established fact that law is a cause of social engineering. So we must use the law to kill the mosquito that bites the slave, because we have no guarantee that if it sees the bottom of the king, it will not do the same. I close on that note.
That's a very instructive one. That's a very instructive one. But quickly also, even in 30 seconds, you can tell me, Mr. Ofeli, whether or not the fate of an executive and a legislature in the issue of defections are fundamentally different. What would you have to say to that?
Well, they are fundamentally different to the extent of the consequential order made. If you look at the executive, for example, Section 141 of the Electoral Act clearly states that you cannot become a governor except you participate in all the stages of an election process. Okay? So where the court now makes a consequential order that the PDP should feed in a governor in the place of Governor Dave Umahi, that consequential order is running contrary to Section 141 of the Electoral Act. And that is why I think that may not fly, okay, because on appeal, that consequential order, I don't think it will fly, not preempting his lordship at the Court of Appeal. But I think it will not fly. But for those legislators who defected, I think their seat is vacant as we speak. But the consequential order also that the court is going to make, or that the court has made as regarding how those seats can be occupied, can the party now produce candidates without elections to represent the constituencies? Okay, the respective constituency, without the people's input, without the electors' input in that case, or is there going to be a rerun? Those are questions of law that must be answered. And given that the lifespan of this administration is almost gone, before appeal is entered and transmission and all that, we may be looking at a situation where time would have defeated the purpose. But I think that is a good one for our judicial system.
I must sincerely thank you for coming tonight, Mr. Evans Ofeli, practicing lawyer and a legal scholar also. Thank you so much indeed for your time tonight.
You're welcome. Thank you.